After being convicted of a crime, have you ever wondered if owning or carrying a firearm would ever be possible again? What types of convictions prevent someone from exercising their God-given Second Amendment right, and what is the process in restoring those rights? That's what we're talking about here in today's post. Stay tuned. If you would like a quick tips cheat sheet to the firearms restoration rights process here in the state of Michigan, head on over to our website, radzwinlaw.com, and on our homepage, if you scroll all the way to the bottom, enter your name, your email address, and then type in the description box gun cheat sheet and click the submit button. I will personally email you the cheat sheet directly to your email inbox. Hello everyone, my name is Joseph Radzwion IV, your trusted attorney with Radzwion Law PLLC. And today this post is covering the topic of deferred or delayed sentences and how that affects the ability for a citizen to restore their right to own or possess a firearm. In previous posts, we looked at the process and how to petition the court in order to restore a citizen's right to own or possess a firearm. You can find that link in the bottom of today's post. Now, the general principle that we have to look at here today is that there's a law that talks about how an individual who's been convicted of a felony will be prevented from owning or possessing a firearm. However, we need to go back to the last day in court, the day of sentencing, and we need to look at what type of sentencing was imposed on a citizen's record or conviction, or what that process looked like. Because it's relevant in the sense there are several statutes in Michigan that will consider a citizen who's been sentenced under this statute as not have been convicted for the purposes of disqualifying them for owning or possessing a firearm under that general rule that we just talked about. These statutes I have listed here. One of them is MCL 333.7411. The other is MCL 769.4A. The other one is MCL 762.11, and that is also referred to as HYTA or HYTA. And then we're also going to look at a court case specifically dealing with the Concealed Pistol Licensing Act. But let's look specifically at 7411. And 7411, that's MCL 333.7411 or 7411. The law states that a discharge and dismissal is without adjudication of guilt and does not constitute a conviction for the purposes of deferred sentencing or any disqualification imposed by law. Likewise, MCL 762.11 or HYTA, if a citizen were to complete a sentence under HYTA, the terms imposed by HYTA, the law will not consider the completion as a judgment or conviction against that citizen. This is good news, again, because if you think back to that general rule, if an individual is convicted of a felony, they will be disqualified under the law to own or possess a firearm. Let's look at another statute. MCL 762.14 talks about if a citizen has completed the HYTA, terms and conditions under HYTA, the law essentially protects that person from being viewed as, or protects them from being stripped from a right or a privilege imposed by law or given or granted by law. So the law under MCL 762.14 reads, an assignment of an individual to the status of youthful trainee as provided in this chapter is not a conviction for a crime, and except as provided in subsection 3, the individual assigned to the status of youthful trainee shall not suffer a civil disability or a loss of right or privilege following his or her release from the status because of his or her status assigned as a youthful trainee. Okay, in other words, MCL 762.14 says a citizen who completes the terms under the HIDA or under 7411 cannot be stripped of a right or privilege for simply being sentenced under that other statute. Similarly, under MCL 769.4a, it talks about how if a citizen has been sentenced under this statute, it will not be considered a conviction, and it's not an adjudication of guilt. All right, so that's good because remember, if you're adjudicated as a felon, meaning the judge decides that you are convicted as a felon, you will be prevented from owning or possessing that firearm. What does case law have to say? What does the court have to say about this sort of thing? There is a case from 2003, Carr v. Midland, that touches on this subject. I'm sorry, it's Carr v. Midland CPL Board. So if a citizen has been convicted of a felony, the Concealed Pistol Licensing Act will prevent that felon or that citizen from, they'll be disqualified for obtaining a CPL under the law. But the court has ruled that a citizen who has successfully completed probation under MCL 333.7411 or 7411 shall not be considered a convicted felon under the CPL, Concealed Pistol Licensing Act. All right, so that is good news for individuals who are looking to apply for a CPL and may have completed successfully those terms under 7411. In conclusion, if a citizen has been sentenced for a crime under one of these delayed or deferral statutes, there is an argument to be made that a felony conviction has not occurred by law and that that citizen will not be disqualified from owning or possessing a firearm. If you like these types of videos, please check out our blog page. Leave us a comment below, share, comment, like, subscribe, hit the thumb notification, all that good stuff. And we'll see you next time. Thanks for watching.